Good evening and welcome to the American Association of University Women's Legal Advocacy Fund Supreme Court wrap-up call for the October 2017 United States Supreme Court term. My name is Ebony Avery Washington, and I am the program manager of the Legal Advocacy Fund here at AAUW. Each year, the Legal Advocacy Fund hosts two Supreme Court calls for AAUW members, a preview call and a wrap-up call. The purpose of the preview call is to give AAUW members insight regarding the cases that the court will be deciding, and the wrap-up call informs AAUW members of the decisions that the court reached, focusing on cases that significantly impact women and girls, as well as highlighting AAUW's legal advocacy before the Supreme Court. As some of you might remember, our preview call last October featured Edith Roberts, editor of SCOTUS blog, which is a resource blog that monitors Supreme Court cases and petitions while providing plain English breakdowns of the legal impact on individuals. During that call, Edith gave AAUW members a preview of cases that have recently garnered national media attention, like Masterpiece Cake Shop, and Janice. We will dedicate the next hour to discussing those decisions and others with our resident expert, Deborah J. Vagans, AAUW's Senior Vice President of Public Policy and Research. At AAUW, Ms. Vagans leads the Government Relations, Legal Advocacy, and Research departments to advance the organization's vision at the local, state, and federal levels. Before joining AAUW, Ms. Vagans was a Chief of Staff and Principal Attorney Advisor at the U.S. Equal Employment Opportunity Commission, where she rendered policy advice and legal interpretations regarding our nation's employment discrimination laws. She served as the agency representative on the White House Council for Women and Girls and the White House Equal Pay Task Force. Prior to joining the EEOC in 2015, Ms. Vagans was a senior legislative counsel on civil rights issues for the ACLU, where she was instrumental in advocating for major civil rights laws, including the Lilly Ledbetter Fair Pay Act of 2009 and the 2006 reauthorization of the Voting Rights Act. Earlier in her career, she was the acting deputy general counsel and senior attorney advisor at the U.S. Commission on Civil Rights and a litigator at two firms, including Cohen Millstone, where she handled trial and appellate work and represented Betty Dukes and the more than 1.5 million women of Walmart in the largest Title VII pay and promotion discrimination class action in history. So we are thrilled to have her here today as our resident expert. Now some housekeeping issues. Due to the high volume of participants on this call, I have muted all lines and we will not be able to take questions from participants on the phone. However, if you have a question during the call, feel free to email your question to laf@aauw.org, and we will try our best to answer them at the end of the presentation of cases, as time permits. We'll be ending at 7 p.m. Now that that's out of the way, welcome, Deb.
Thank you, Ebony. It is a pleasure to be with all of you tonight to discuss some of the Supreme Court cases this past term that impact the mission of AAUW. I also want to thank Ebony for all her hard work running our LAF program and in preparing for our call tonight. And I'd also like to thank Kate Nielsen, our State Policy Counsel, and Michaela Cohen, our legal intern, for all of their work helping with this Supreme Court research.
Deb, there was a significant announcement at the Supreme Court about a month ago. Maybe you heard. On June 27, 2018, Justice Anthony Kennedy announced that he will retire at the end of this month after 30 years on the bench.
Yes, the decisions we're going to talk about tonight aren't the only news from the Supreme Court this year. Justice Kennedy announced his retirement, and President Trump nominated Judge Brett Kavanaugh to fill the vacancy. During his 30 years of service on the Supreme Court, Justice Kennedy was a critical vote in several landmark cases, from LGBTQ rights and marriage equality to affirmative action in education, to criminal sentencing reform. It is important to note that while generally called the swing vote on the court, he was not always a reliable vote to protect women's reproductive health choices or other civil rights. Moreover, of the 6 cases I will discuss tonight, he sided with the AAUW. He sided against the AAUW position as a member of the majority in all of them. So while not always the swing vote we needed, over his career, Justice Kennedy has, though, been willing to curb some of the Supreme Court's most extreme decisions. As everyone knows, the Supreme Court is the arbiter of so many of the rights that are essential to the health, education, and economic security of women. Indeed, as you will hear today, the court continues to put out numerous decisions contrary to the public policy positions of AAUW. Therefore, it is crucial that Justice Kennedy's successor be a fair-minded and independent jurist who understands that his decisions have a very real impact on the daily lives and decisions of women and their families. Any nominee must be the result of meaningful bipartisan consultation, fully vetted by the Senate, and held accountable for any record of bias. AAUW is currently evaluating Judge Kavanaugh's record. Simultaneously, as the Senate provides their constitutionally required role of providing advice and consent on Judge Kavanaugh's nomination, we are encouraging them to fully and fairly vet his nomination to ensure he will uphold the protections that are critical to the equity of women and girls. So, on that note, we urge you to visit www.aauw.org, where you will find a link on our homepage to urge your senators to fully and fairly vet Brett Kavanaugh. By simply entering your name and address, you can make your voice heard, and I hope that you will do so. So as you will hear tonight, our most fundamental rights and freedoms can be overturned by one vote on the highest court, and if confirmed, Judge Kavanaugh will have a say in the decisions that impact the health, education, and economic security of women and girls for decades to come.
The nominee might also have a direct impact on our legal case support program in the near future. As most of you know, we have been providing financial support to Aileen Rizzo in her fight for fair pay. On April 9, 2018, she had an important victory before the Ninth Circuit under the Federal Equal Pay Act of 1963. The Ninth Circuit held that using prior salary alone as a factor other than sex, or in combination with other factors, cannot justify an employer paying a man more than a woman for the same work, reasoning that this would perpetuate a gender wage gap in direct contrast with the intent of the Equal Pay Act. This was an important victory for Aileen, and the decision has far-reaching consequences. The defendants, Fresno County, has indicated its interest in filing a petition for appeal with the Supreme Court and has until the end of August to do so. AAUW will continue to support Aileen through our legal case support program as her case is considered for review. One way you can stay informed about Aileen's case and the other cases we support is through the LAF Express, the monthly newsletter that provides updates regarding LAF cases, our amicus efforts, and our legal advocacy. If you subscribe to LAF Express, then you know that AAUW signed onto 2 amicus briefs in cases where we argue before the Supreme Court this term, one of which is our first case on the agenda for discussion tonight.
Thanks, Ebony. I also want to provide just a brief overview to say that of these cases, you will see that even with Justice Kennedy on the court, we are seeing a rollback of some of our most fundamental rights, as well as a weakening of our nation's civil rights and employment statutes. And I'll go over some of those. But let me start with one of the cases we signed on to as an amicus, or as we say, a friend of the court. So Justice Sotomayor has stressed the importance of recognizing that the law has real-world implications on real people. And that's a perfect place to lay the foundation for our first case, and that is the National Institute of Family and Life Advocates, or NIFLA, versus Becerra. In this case, Justice Thomas delivered the opinion of the court. It was a 5-4 decision, a lot of these are, with Justices Breyer, Ginsburg, Sotomayor, and Kagan dissenting. So in this case, NIFLA challenged the California Reproductive Freedom, Accountability, Comprehensive Care, and Transparency Act, with the acronym FACT Act, which required licensed pregnancy centers to post or hand out information about the availability of low-cost or free family planning services, prenatal care, and abortion services, as well as a phone number to contact to determine eligibility for those services. The law also required unlicensed pregnancy centers to post or hand out information that makes it clear that they are not licensed by the state of California and do not have a licensed medical provider on staff or under contract. The issue before the court was whether the notice requirements violate free speech protected by the First Amendment. Before we examine the reasoning of the court, let's talk a little bit about why we call these centers fake pregnancy centers. NIFLA refers to the facilities as crisis pregnancy centers, but that is a misnomer. In fact, as I mentioned, the advocacy community describes them as fake health care facilities that are not affiliated with a licensed physician, do not inform women of their full rights when faced with a pregnancy, and do not provide a full range of medical services. They use harmful and deceptive practices to prevent women from accessing the full range of medical services offered by the state. So shortly after the California governor signed the law, the centers in this case went to court, asking a federal judge to put the law on hold while they litigated their First Amendment challenge. The district court declined to do so, and the U.S. Court of Appeals for the Ninth Circuit affirmed that ruling, holding that the centers had not shown that they were likely to prove a First Amendment violation here. The Supreme Court agreed to review that ruling, and the justices reversed. By a vote of 5-4, the justices ruled that the centers were likely to prevail on their argument that the law, which requires the centers to make specific disclosures to their patients or in advertisements, violates the First Amendment. This is a problematic decision. Let's take a look at the court's reasoning. The majority concluded that the notice requirements were what we call content-based. That is, the state wanted to target the speech of the licensed centers based on its communicative content by requiring them to notify pregnant women about the availability of all their medical options, even though the center's goal is to persuade women not to have abortions. Laws that regulate speech based on their content are normally subject to the most stringent standard of legal review we have, but the majority argue that even if the notice requirement for licensed clinics were subject to a less exacting standard of review, the law still does not pass constitutional muster for two reasons. First, the majority asserted that the law was under-inclusive because it only applies to clinics that have the primary purpose of providing family planning or pregnancy-related services, while excluding several other types of clinics that also serve low-income women that could also educate about the state's services. And two, there were other ways for the state to notify women about the availability of state-subsidized abortions without requiring these clinics to do so for it, like ads or public notices. The majority reached a similar conclusion for the unlicensed centers, finding that the requirement still placed too much of a burden on the unlicensed centers' speech. Concluding both that the licensed and unlicensed pregnancy centers were likely to succeed on their First Amendment claims, the majority reversed the Ninth Circuit, ruling in favor of the state, and sent the case back to the lower courts for new proceedings. So in short, with this holding, 5 justices struck down a neutral state law requiring factual disclosures in favor of the rights of clinics to spread misinformation. The FACT Act did not prevent these clinics from providing their own services and continuing their anti-abortion speech. It just required them to be honest about what they were doing. Proceeding unchecked, these clinics provide false, misleading, or incomplete information which can compel women to make uninformed decisions about their healthcare options. These decisions are often time-sensitive, so in addition to seeding confusion, these clinics often succeed in undermining women's access to a full slate of reproductive health care options. Since these types of clinics operate across the country, not just in California, this holding could undermine other women's fundamental right to choose and jeopardize their health care. Clearly, this holding is contrary to AAUW's positions. AAUW supports the right of every woman to access safe, affordable, and comprehensive reproductive health care. And we trust that every woman has the ability to make her own informed choices regarding her reproductive life within the dictates of her own moral and religious beliefs. To do this, women need accurate, factual information. To that end, we signed on to an amicus brief with 50 other diverse organizations arguing that California's FACT Act be upheld in light of these principles. The brief highlighted stories of women who tried to seek medical services through these facilities, exposing how the facilities, in reality, withheld accurate, necessary information about reproductive health services.
Thanks for that explanation, Deb. Let's move into another case that garnered a lot of public interest, and that will be Masterpiece Cake Shop versus Colorado Civil Rights Commission. This case was decided 7-2. Justice Kennedy delivered the majority opinion, with Justices Ginsburg and Sotomayor dissenting. This case received a lot of media attention. As you may already be familiar with the facts, but I'll go over them again quickly. Masterpiece Cake Shop is a Colorado bakery owned and operated by Jack Phillips, a baker and devout Christian. In 2012, he told a same-sex couple, Charlie Craig and David Mullins, that he would not make a cake for their wedding celebration because of his religious opposition to same-sex marriages. At that time, Colorado did not recognize same-sex marriages. Jack offered to sell them other baked goods, but refused to sell them a wedding cake he would have to make. The couple filed a charge with the Colorado Civil Rights Commission, which we'll refer to as the Commission, alleging a violation of Colorado Anti-Discrimination Act, or CADA, which prohibits discrimination based on sexual orientation in a place of business engaged in any sales to the public and any place offering services to the public. The Commission opened an investigation which found that on multiple occasions, Phillips turned away potential customers on the basis of their sexual orientation, stating that he would not make a cake for a same-sex wedding ceremony or reception because his religious beliefs prohibited him from doing so. The investigation found that Phillips had declined to sell custom wedding cakes to about 6 other same-sex couples, in addition to Craig and Mullins, showing a pattern of behavior necessary to provide a violation of the CADA. The Commission then referred the case for a formal hearing before a state administrative law judge, or ALJ, who ruled in the couple's favor. In doing so, the ALJ rejected Phillips' claim that requiring him to make a cake for a same-sex wedding would violate his First Amendment rights. Later, the Colorado Court of Appeals affirmed the ruling in favor of the couple. The Supreme Court took it up, however, and ruled 7-2 in favor of the baker. This decision was a narrow one, applying only to the specific facts of this case and not directly addressing the larger, overarching questions of LGBTQ discrimination and free speech. Nonetheless, the importance of this outcome and its possible consequences should not be underestimated. Deb, can you tell us a little bit more about this case?
Sure, and of all the cases I'll discuss today, this, for lack of better words, is the least bad, meaning not a victory and not a total loss. Let me explain. As Ebony said, the underlying issue in this case, whether someone can claim a First Amendment exemption to the Colorado Anti-Discrimination Act, meaning whether or not they can refuse service to LGBTQ couples, was actually not decided. The relevant part of the Colorado law prohibits discrimination on the basis of sexual orientation, as well as other protected characteristics in public accommodations. The Act defines public accommodation as place of business engaged in any sales to the public and any place offering services to the public. So, given the definition, it's easy to arrive at the conclusion that the baker violated the Colorado law. But the question before the court was whether the state law violated his First Amendment rights not to provide his services to an LGBT couple based on his religious beliefs. The court left this question unanswered and chose instead to focus on the commission's treatment of the baker while conducting the investigation. At the commission's formal public hearings, some commissioners asserted that religious beliefs cannot legitimately be carried into the public sphere or the commercial domain where the baker operated, and compared the baker's assertion of religious beliefs, which do discriminate against LGBT couples, to defenses of slavery and the Holocaust. The court found that this treatment showed elements of improper bias against the baker's sincere religious beliefs and determined that these sentiments were inappropriate given the commission's duty to be fair and impartial in enforcing Colorado's anti-discrimination laws. The court also interpreted these sentiments as official expressions of hostility to religion and found that Phillips was treated differently by the commission than other baker business owners who had actually objected to anti-gay messages on cakes. Ultimately, these actions were found to be inconsistent with the free exercise clause of the First Amendment because the law was not applied in a neutral manner towards religion. Now that we have an understanding of what the court did decide, that the baker wasn't treated fairly, I want to point out what the court did not say. The court did not say that the baker or any other business has the right to discriminate. Importantly, the court also stated that our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. While we cannot call the holding of this case a win, it is notable the court made the statement and that it did not weaken any existing protections. In understanding the repercussions of this case down the line, the major takeaway is that it is a very limited decision. The baker ultimately won on a process issue, but the tenets AAUW advocates for remain in place. For our part, AAUW strongly opposes all forms of discrimination and supports constitutional protections for the civil rights of all individuals. For far too long, rights and protections have been denied to the LGBTQ community. Currently, there is no explicit federal law that prohibits discrimination based on gender identity and sexual orientation in public accommodations, although the EEOC currently interprets employment laws to include federal LGBT protections. Fortunately, the rights of LGBTQ individuals are protected under many, but not all, state laws. And unless and until all persons are able to enjoy the same rights and freedoms, the promise of equal justice under law will remain unfulfilled. It is worth noting that in past years, religious grounds have been asserted and rejected to deny employment and public accommodation rights to minority citizens. This concept should not be revived here. From here, we have to watch the cases that are yet to come. This case itself could make it back through the courts and come all the way back up. There is another case out of Washington State pertaining to a florist that has a similar fact pattern to the Masterpiece Cake Shop case. So we have to keep an eye out on that one because currently the Supreme Court is considering whether it will accept it on appeal.
Okay, Deb, from there, let's transition into another case where we petition the Supreme Court by signing on to the amicus brief as a friend of the court. Let's look at Sveen v. Mellon. Justice Kagan delivered the opinion of the court in this 8-1 decision, in which Justice Gorsuch dissented.
This case didn't make headlines, but it is of significance to AAUW. Sveen v. Mellon addressed whether what is called a revocation on divorce statute violates the contract clause of the Constitution. So let me unpack that a little bit. There was a Minnesota statute in question here, which automatically rescinded the designation of a spouse who was a life insurance beneficiary if the parties divorced, regardless of the intent of the deceased ex-spouse. This case looks at whether that kind of law is in conflict with the Contracts Clause of the Constitution, which generally limits a state's ability to interfere in existing contractual relationships, like a life insurance policy. Many states are adopting these revocation on divorce statutes, which would allow a state to limit the former spouse from claiming benefits upon the death of their divorced partner. The case involves a Minnesota woman who was still the named beneficiary on her ex-husband's life insurance policy when he died. In this case, Mark Sveen purchased a life insurance policy in 1997 and married Kay Mellon later that year. In the following year, he named her as the primary beneficiary on his life insurance policy and his 2 adult children from a prior marriage as contingent beneficiaries. Mark and Kay divorced in 2007, but Mark never changed the beneficiary designation on his policy. In 2005, 5 years after Mark had designated his wife Kay as the primary beneficiary, Minnesota amended its law to automatically revoke life insurance designations of a former spouse after divorce. So when Mark died in 2011, Kay was still the primary beneficiary on the policy. Mark's children and Kay both filed claims for the proceeds, but because of the confusion over the retroactive application of the law, it ultimately landed in court. The district court in Minnesota found in favor of the children, but the U.S. Court of Appeals for the Eighth Circuit reversed the lower court's decision and concluded the revocation on divorce statute was unconstitutional when applied retroactively. The Supreme Court then reversed the Eighth Circuit and ruled that revocation on divorce statutes do not violate the Contracts Clause of the Constitution. So let's look at how they arrived at that decision. Kay Mellon argued that the retroactive application of the 2000 law was a violation of the Contracts Clause, which restricts the power of states to disrupt contractual arrangements. But not all laws affecting pre-existing contracts violate the Contracts Clause. The court applied a 2-step test to determine when a law like this crosses the constitutional line. The first step is to determine whether the state law has operated as a substantial impairment of a contractual relationship. In answering that question, the court considers the extent to which the law excessively meddles in an already existing contract. If these factors show a substantial impairment, the court then asks whether the state law is drawn in an appropriate and reasonable way to advance a significant and legitimate public purpose. And in analyzing this case, the court stopped after step 1 because it found that Minnesota's revocation on divorce statute did not substantially impair a pre-existing contractual arrangement. The court relied on 3 points to make that determination. First, the court said that this statute is merely designed to reflect a policyholder's intent after divorce, meaning they divorced, so we would take the person out from being a beneficiary. So the statute supports rather than impairs the contract framework. Second, the law is unlikely to disturb any policyholder's expectation because it does no more than a divorce court could have done. And third, the statute supplies what we call a default rule, which the policyholder can undo by just reestablishing the previous designation if they really want their former spouse to collect. According to the majority, the legal system has long used default rules to resolve estate litigation in a way that they believe conforms to the deceased's intent. Therefore, the court held that the retroactive application of Minnesota's statute does not violate the Contract Clause. Unfortunately, the holding in this case has negative practical ramifications for women. While seemingly gender neutral on their face, these modern revocation upon divorce statutes, which are in place in at least 26 states, actually have a tendency to harm women as applied. These statutes disproportionately cause damage to women's economic security. They more frequently revoke beneficiary designations of women. They deprive women of larger benefits than men, and they disproportionately affect financially vulnerable divorced women. And because of the gender pay gap, on average, women bring home less money than men to begin with. This gap compounds throughout a lifetime, leading to smaller retirement savings for women and therefore less retirement security. Because women are less likely than men to hold sufficient resources for a stable retirement, revoking the benefits of a divorced woman can have dire financial consequences. In February 2018, we joined an amicus brief challenging the Minnesota statute. The brief highlighted the connection between discriminatory public policy like these revocation on divorce statutes and persistent disparities in societal and economic power between women and men, and argued that divorced women were disproportionately harmed. While this factor should have called into question the validity of the Minnesota statute, it was not adequately weighed in the court's opinion. So with all this background in mind, you might be curious about the breakdown of the vote alignment in this case. All of our stalwarts for women's rights sided with the majority opinion, and only Justice Gorsuch dissented. Moreover, the amicus brief we joined was cited in Justice Gorsuch's dissent. But Justice Gorsuch's argument is not centered on the impact of these statutes on women. Rather, he focuses on how retroactive revocation on divorce statutes substantially impair contracts by presuming the intent of the deceased and removing the component that is essential to the contract itself, the original beneficiary's name. While we are disappointed with the outcome of this case and agree that the state should not assume what is or is not the intent of the divorcing spouse with respect to the financial security of his former spouse, we don't fully support Justice Gorsuch's dissent. His analysis would apply an inflexible standard, essentially ensuring that any new law altering an existing contract would be invalid. This could be extremely detrimental to forward progress as our legislators work to update and invent new laws. Consider new employment laws that add protections for workers. If those could not be retroactively applied to existing labor or employment contracts, workers would not be able to enjoy the benefits of progressing policy.
And speaking of labor and employment rights, Deb, let's move into our next case for discussion. Janus versus the American Federation of State, County, and Municipal Employees Council. Janus is one of two labor cases that Deb will touch on tonight. AAUW was interested in this issue raised by Janus because the fight for workers is important in securing economic security for all, but especially for women. The court decided this case 5-4, with Justice Alito delivering the majority opinion while Justices Sotomayor, Kagan, Ginsburg, and Breyer dissented. Deb, can you expand on the issues presented within this case?
Definitely. The situation before the court in Janus concerned public sector unions, which represent employees in government and government-funded industries. So Illinois law permits public employees to unionize. If a majority of the employees in a particular industry or bargaining unit vote to be represented by a union, then that union is designated as the exclusive representative of all of the employees in that industry or bargaining unit, even those who did not join the union. This is significant because once formed, only the union may engage in negotiations with employers, also known as collective bargaining. So in Janus, the court considered whether the collection of fees from non-union members to support public sector union activities violated the First Amendment by requiring these non-members to fund positions they may object to in collective bargaining and related activities. The facts of the case involved Mark Janus, a state employee and non-member of a public sector union in Illinois, who filed suit because of these required agency fees. And agency fees are a portion of the employee's salary and are vital to funding services provided through the union. The case was originally dismissed on the grounds that the issue had already been decided by a previous Supreme Court case, Abood versus Detroit Board of Education, in which the court held that although non-union employees in the public sector could not be required to fund the political or ideological activities of a union, they could still be required to pay the agency fee, which funds the union activities relative to the collective bargaining and other non-political, non-ideological union activities. Despite this long-held precedent set by Abood, In Janus, the court ultimately held that the collection of agency fees from a non-union member for purposes of supporting any public sector union activities, including collective bargaining for better wages and benefits for everyone, was indeed a violation of the First Amendment and that AAUW should be overruled. The Supreme Court discussed many arguments in deciding this case, but the argument most important to those focused on workers' rights is this issue of free riders. So free riders is a term describing those who would benefit from union services without paying for those services. As I've mentioned, unions are required to represent all employees in a particular unit or industry, whether they pay union dues or not. Allowing for free riders results in unions that are undersourced and underfunded and therefore less able to provide critical services to employees. In analyzing whether the public sector union in question had violated the First Amendment, the court needed to decide whether the free riders argument constituted a compelling state interest to continue the fees. In this case, the union argued that the compelling state interest was to support collective bargaining and workforce efficiency through well-funded union. The court, unfortunately, ultimately found that the free rider argument was not a compelling state interest because unions could somehow be effective and sufficiently funded without agency fees, and the court asserted, without much support or explanation, that there were other methods to address the free riders without having to collect agency fees and violating the First Amendment. In so deciding, the court overruled 40 years of precedent. So the holding in this case is far-reaching, not only because it undoes decades of precedent, but because it significantly weakens unions and disproportionately hurts working women. Unions play a critical role in securing many of the core principles that AAUW advocates for: fair wages, access to health care, retirement security, paid leave, anti-discrimination protections, and more. And while unions advocate for these policies for all workers, they have a particularly large impact for women and workers of color. For example, research shows that the gender and racial pay gaps are smaller among union members than non-union members. Because public sectors have a legal duty to represent both members and non-members alike, they will continue this vital work of advocating for workers. But with this holding, individuals will not have to pay for the hard work of union representatives, even if they are directly benefiting from their actions. The collective worker voice and bargaining power will be weakened by this harmful decision.
And our next case for discussion is also a labor case, and that is Epic Systems, Inc. v. Lewis. The court decided this case 5-4, with Justice Gorsuch delivering the majority opinion, while Justices Ginsburg, Breyer, Sotomayor, and Kagan dissented. AAUW is interested in this case because it involves the enforcement of mandatory arbitration clauses in employment contracts, which force employees to condition employment on waiving their rights to go to court when a dispute arises. We have long opposed pre-dispute mandatory arbitration clauses because they impede employees' ability to combat discrimination, sexual harassment, and other civil rights issues in the workplace. Unfortunately, the decision in Epic Systems was a huge blow to workers' rights.
It is unfortunate that we're now looking at several cases that have been hostile to employment and labor rights. Let me talk a little bit more about this one. This case involves the interaction between the Federal Arbitration Act, which provides that arbitration agreements are generally valid, irrevocable, and enforceable, and the National Labor Relations Act, which makes clear that employees have the right to band together for mutual aid and protection. Epic Systems is a healthcare data management software company based in Wisconsin. Their employee contracts include a mandatory arbitration agreement, which is a condition of employment, meaning you must sign it in order to have the job. These contracts require employees to waive their rights to go to court to resolve disputes and instead require them to proceed with an individual arbitration, which provides less protection and due process than a court proceeding, among other problems. In addition to waiving the right to go to court, employees also must forego the right to participate in class actions or collective lawsuits, which are critically important procedural processes for fully vindicating labor and employment rights. In February 2015, Jacob Lewis, a former employee of Epic Systems, sued them in district court in Wisconsin individually for himself and on behalf of other employees, claiming that they had been denied overtime wages in violation of the Fair Labor Standards Act. In response, Epic Systems moved to dismiss the complaint because they said that the arbitration agreement would require Lewis to arbitrate his claims rather than bring a lawsuit. Epic Systems also argued that the agreement was enforceable under the Federal Arbitration Act. The employees, on the other hand, argued that the FAA has what is called a savings clause, which would remove the obligation to arbitrate if it violates some other federal law. In this instance, the employees argued that by requiring an individualized process, the agreement here violated the National Labor Relations Act protections that allow collective action. So the Federal District Court and the Seventh Circuit Court of Appeals ruled in favor of Lewis and held that the arbitration agreements of this kind in employee contracts are unenforceable. At the Supreme Court, 3 similar cases were argued together. Each arose when an employee who had signed an employment agreement that contained an arbitration provision, filed a lawsuit in federal court, seeking to bring both individual and collective claims. The employers argued that under the terms of their arbitration agreements, the employees needed to go to individual arbitrations. So the issue before the Supreme Court then was, does the National Labor Relations Act prohibit enforcement of a mandatory individualized arbitration agreement that would be permissible under the Federal Arbitration Act alone? Unfortunately, the Supreme Court ruled in favor of Epic Systems, stating that there is nothing in the National Labor Relations Act that trumps the Federal Arbitration Act's requirement that arbitration agreements be enforced. The majority rejected the employees' arguments that the NLRA's right to engage in concerted activities for the purpose of collective bargaining or mutual aid and protection trumps the Federal Arbitration Act's command to enforce arbitration agreements. So even though the NLRA focuses on the right to bargain collectively, the majority refused to extend that concept to class or collective action procedures. The dissent argued that the intent behind the National Labor Relations Act was to remedy the power imbalance between employers and employees in many areas, including collective actions in dispute resolution. The imbalance in the employee-employer relationship, in fact, prompted Congress to enact the NLRA to help employees in taking collective action to match the power of their employers in establishing terms of employment. Like the holding in Janus that we just talked about, the case dealt a blow to workers' rights. To achieve economic self-sufficiency for all women, AAUW advocates for vigorous enforcement of employment protections. Unfortunately, the holding in this case severely undermines the ability of workers to fight discrimination. The arbitration process is often secretive and expensive, preventing women from banding together to bring their employers to task for wrongdoing and silencing women's collective voices because of the disincentive to move forward with a claim. In fact, studies show that workers are both less likely to go forward and less likely to win in mandatory arbitration. Moreover, as the dissent notes, it will be rarely worthwhile for individual employees to pursue their own claims. It is much more effective to advocate in large numbers, and victims are rarely alone in their experiences. But even if they might otherwise be willing to do so, many may fear retaliation if they go it alone. The result will be that employers may weigh the cost-benefit analysis and balance the underpaying of workers in favor of circumventing legal obligations. In other words, employers may lack the incentive to ensure that they are upholding lawful workplace policies. Ironically, enforcing mandatory arbitration agreements actually serves to condition employment on waiving the very laws that protect employees in the workplace. Undermining class action lawsuits and forcing secretive mandatory arbitration arrangements not only hurts individuals, but likely suppresses progress for many.
And that brings us to our last case, Houston versus A. Philip Randolph Institute. This case involves voting rights and the Voting Rights Registration Act. National Voter Registration Act. This case was also decided in a 5-4 decision with Justice Alito writing the opinion of the court with Breyer, Ginsburg, Sotomayor, and Kagan dissenting.
So this will be my last bad news of the night. So thank you all for listening. The Supreme Court has said in earlier courts that the right to vote is preservative of all other rights. And indeed, that is one reason voting rights cases are so critical. In order for us to have a say in the political process, which determines who decides all of our other rights, we must not have our voting rights restricted. So the issue before the court in this case was Ohio's voting roll maintenance process. Like other states, Ohio requires voters to reside in the district where they vote, and when voters move out of that district, they become ineligible to vote there. According to the Census Bureau, more than 10% of Americans move every year. Prior to 1993, the states had the sole authority of maintaining accurate voting lists of those eligible to vote in federal elections. This changed in 1993 with the enactment of the National Voter Registration Act, or the NVRA, or what we may better know as the Motor Voter Law. So there are two main aims of the NVRA that are at issue in this case. First, increasing voter registration, and two, removing ineligible people from state voter registration rolls. Generally, the process for removing voters from the registration rolls must be uniform, non-discriminatory, and in compliance with the Voting Rights Act of 1963, and must not be based solely on the individual's failure to vote, or what would be called a violation of the failure to vote clause in the NVRA. So the NVRA gives two permissible justifications for removing a person from the state voter registration rolls, and that is death or their change of residence. But a state may not remove a registrant's name on change of residence grounds unless the registrant confirms in writing that he or she has moved, or the registrant fails to return a specific card. This card must explain what a registrant who has not moved needs to do in order to stay on the rolls. Basically, return the card or vote during the next two general federal elections. If the state does not send a card or otherwise receive written notice that the person has moved, it may not remove the registrant on change of residence grounds. The NVRA gives discretion to the states about when the card is mailed, and different states approach this requirement differently. Ohio's specific process is being challenged as discriminatory in this case. So with that backdrop in mind, here are some brief facts of this case. Larry Harmon is a U.S. Navy veteran and has been voting since 1976 and has lived in the same home for more than a decade. Mr. Harmon voted in the 2008 presidential election but chose not to vote in 2010, 2012, and 2014 federal elections. He had also not responded to, because he said he did not remember receiving it, a notice that the state elections board had sent him in 2011 to confirm his eligibility. In November 2015, Mr. Harmon went to the polls on Election Day to vote on a ballot initiative, but was told that his name did not appear in the poll book. In fact, Mr. Harmon had been removed from the voter registration rolls despite not recalling receiving a confirmation notice to confirm his voter registration. The ACLU of Ohio, and DEMOS, on behalf of the A. Philip Randolph Institute, the Northeast Ohio Coalition for the Homeless, and Larry Harmon, collectively, filed suit against the Ohio Secretary of State. The suit claimed that Ohio's process violated the NVRA and the Help America Vote Act, which is a companion piece of legislation, and sought injunctive relief to stop this purging process. In the lawsuit, the plaintiffs alleged that the Ohio process should be stopped because it violated the failure to vote clause. The plaintiffs argued that by using a resident's failure to vote twice, first as the trigger for sending the return cards, and then second as a trigger for removal, it actually meant that that failure to vote became the sole factor in the justification of removal in Ohio's process. The district court rejected that argument and found in favor of the Secretary of Ohio, holding that Ohio's process mirrors the permissible procedures established in the NVRA for removing people on change of residence grounds because it also included a notice provision. Therefore, the mechanism, according to the court, does not violate the failure to vote clause because it does not remove anyone solely for their failure to vote technically. The Sixth Circuit Court of Appeals reversed the district court, ruling that Ohio did violate the NVRA. The Supreme Court then reversed the decision of the appellate court, holding that the process Ohio used to remove voters on change of residence grounds did not violate the failure to vote clause or any other part of the NVRA. The Supreme Court found that Ohio's process is permissible because technically it does not remove a registrant on change of residence grounds unless the registrant is sent and fails to mail back a return card and then fails to vote in 2 general elections for federal office, which is about over the course of 4 years. The Supreme Court rejected the argument that Ohio was using non-voting as the sole criteria for removing a registrant, and instead they asserted that Ohio removes these voters only, as we've said, if they have failed to vote and have failed to respond to a notice. Because inactivity and failure to respond were both included in Ohio's processes, it was considered permissible, even though they were both triggered by a failure to vote. So the court's reliance on notification here the court's reliance on notification here to justify this purging problem is a troubling decision. While we want everyone to vote, in America you have the right not to vote if you so choose, and doing so should not let the state functionally make you ineligible to vote. Large swaths of the American public do not vote every 2 years. Turnout is notably lower in non-presidential elections. That inactivity alone, then triggering the process to return a nondescript postcard from the state, can easily lead to removal from the polls without true notice. Just as an example, you may move within the same polling place. You may not be the registered voter on the card. You may never receive it. Why should you lose the most fundamental of rights under such conditions as long as you remain eligible to vote? But perhaps most importantly, this will result in a myriad of eligible voters, disproportionately minority, low income, disabled, veteran, and high mobility voters, showing up at the polls realizing they are no longer registered. While not a wholesale green light to conduct unfettered purges, this misguided attempt to clean up voter rolls functions as a voter suppression tactic. And research shows that these attempts to undercut voting rights are working. The Brennan Center estimates that the median rate of purging has dramatically increased at a statistically significant level since 2008, resulting in about 4 million people being purged from voting rolls. Combined with the Supreme Court's disastrous decision in Shelby v. Holder in 2013 to overturn part of the Voting Rights Act, discriminatory voter ID laws, and cutbacks to early voting, many states are making it harder rather than easier to cast a ballot. By taking away the voice of the people, these restrictive and discriminatory practices are barring individuals from voting for the very changes that we need. For decades, the Department of Justice, which enforces the NVRA, maintained that these kinds of purges were illegal in both Republican and Democratic administrations. State laws that tend to limit access to the ballot weaken a core tenet of our democracy. To guarantee equality, individual rights, and social justice for a diverse society, AAUW advocates for the vigorous enforcement and full access to civil and constitutional rights, including expanding voting rights. The holding in Houston undermines those principles. Before I conclude on this last case, I want to take a moment to highlight a portion of Justice Sotomayor's dissent because I find it not just moving, but because it identifies the important role of AAUW and other advocacy organizations in strengthening our civil rights laws for all. She writes, Communities that are disproportionately affected by unnecessarily harsh registration laws should not tolerate efforts to marginalize their influence in the political process, nor should allies who recognize blatant unfairness stand idly by. Today's decision forces these communities and their allies to be even more provocative and vigilant in holding their states accountable and working to dismantle the obstacles they face in exercising the fundamental right to vote. So, Ebony, that's my overview of 6 important cases from the Supreme Court this last term. I hope that in addition to explaining the cases and their importance to AAUW's values and mission, I have given a flavor of the erosion of some of our most fundamental rights that is happening at the court and how frequently one vote can matter in the outcome of cases that impact women and girls for generations. If there's any time left, I'm happy to try and answer any questions that have come in.
Thanks, Deb. That was a tremendous effort there. Thank you for your thorough review of those 6 cases. We do have a few moments for questions, maybe one question we can squeeze in here. So I will start with this one that we received. It's regarding the NIFLA case. How might the decision in the California NIFLA case affect other states and their reproductive rights?
Thanks, Ebony. Just as a quick review, because it was the first case I talked about, the stated purpose of that California law, the FACT Act, including its licensed notice requirement, was to ensure that California residents make their personal reproductive health care decisions knowing their rights and the health care services available to them. That was the stated purpose of the law. The decision in NIFLA means that these centers can continue to provide misinformation with no requirements to tell women the truth about the services that are available to them in California. However, NIFLA has over 1,400 member centers in nearly every state, and there are many other clinics represented by other organizations. NARAL estimates that there are over 3,500 clinics like this nationally. While this case only involved the FACT Act, the California law, and the one that it struck down, it negatively impacts reproductive rights in other states. As I mentioned, it pertained only to the constitutionality of that act, but its implications are broad because the reach of the clinics and their harmful and deceptive practices. The most immediate outcome of the case is that other states will either be stifled from passing laws similar to the California FACT Act, or for states that have similar laws already in place, the decision portends more rollbacks of laws seeking to ensure women have access to complete and factual information and care.
Okay, thanks, Deb. Well, we're just about out of time for tonight's review, so I'll just say a few final thoughts here. I do hope that you all have enjoyed the AAUW review for our October 2017 Supreme Court term. The AAUW Legal Advocacy Fund will be hosting a Supreme Court preview call for the court's next term this October. If you would like to hear this presentation again or want to share it with others, a recording will be made available online in a few weeks. I want to take another opportunity to encourage you to sign up for LAF Express so you can stay apprised of our legal advocacy efforts and the cases we support through our legal case support program. I'd also like to encourage you to visit aauw.org and call on your senators to demand a full and fair vetting of Judge Kavanaugh or any nominee for the Supreme Court. Finally, I again want to thank Deb, AAUW's Senior Vice President of Public Policy and Research, for sharing her insight, knowledge, and expertise regarding these cases and their real-world implications for all of us. Again, my name is Ebony Avery Washington, Program Manager for the Legal Advocacy Fund, and I want to thank you for your time and attention during this call. Have a wonderful night.